Welcome to IRMS London. We now have Andrew Latham with the Information Case Law Update.
Thanks very much for having me. This session is a collection of case law, largely on data protection. But before we get into that, I kind of want to just talk about why people get sued and how claims work, because I think that bit is sometimes sort of glossed over in terms of legal updates and things like that. And actually, I think that's quite important to understanding why we get some of the litigation that we get and why we get some of the outcomes that we get. As I say, my interest tonight is largely on data protection. A bit about me, my background is health law primarily, so working for NHS bodies and other providers of health services and helping them make hopefully good decisions that benefit patients, or at least try and keep them out of trouble. And so that's my kind of perspective on this this area. The health warnings are twofold. Lawyers, myself included, and I tar us all with the same brush, love making text heavy, unexciting slides. So I thought I'd do an interesting slide first of an astronaut saying hello to a horse. The reason that I do text heavy slides is that you're very welcome to look at these, or I can ping them across to you at some point if that's helpful. I often go to seminars or go to events and the slides have just got like the word issues ? On them, and my mind starts wandering at that point, and then I lose track of what's going on, and then I'm looking at the slides at some point in the future and I don't have a Scooby-Doo what's going on. So the thought process in terms of the way that I produce these is that it's a resource that if you want to go back to at some point, you can do. Please do ask any questions that you've got as we're going along, and Emily can interrupt me to ask anything. The other health warning is that I have a toddler who's got bath time going on at the moment, and there may be a small child in probably no clothes running around in the background in about 3 minutes time. So if that happens, my apologies.
For any concerns for people aware that this is being recorded, it will be taken out of the recording if it happens, just to avoid that concern. But in relation to questions, Andrew, if they find the chat box, people that have been here before should know where the chat box is. Can you say hi to me on the chat? It's where you select to leave the meeting. There is a little speech bubble that allows you to actually type messages to me, and I can kind of give those to Andrew. Yep, people are finding it. That's great. Right.
Brilliant.
Carry on, Andrew. Sorry.
Thanks very much. So a question that I get asked a lot is, will I get sued if I do something or if I don't do something? And there isn't actually an answer to that. You might get sued, you might not get sued. The circumstances in which people get into legal difficulty, be it regulatory action or legal action, is largely because they've done something that they shouldn't have done, or they haven't done something that they should have done. And going back to our speeding footballer, obviously they've done something that they shouldn't have done. But equally, if you fail to get your car MOT'd, then you haven't done something that you should have done. What then needs to happen is someone's got to find out about it who cares enough about the situation in order to get to a point in time of deciding to take legal action about what's going on. And their motivations might be because they've been harmed by something directly. It might be because they are a regulator and it's their job to get cross about what's going on, or to take a incisive view about what's going on. And obviously there's a lot of stuff going on at the moment about contact tracing and the relative role of the Information Commissioner or other regulators in that space. And just kind of on the contact tracing point as an example, so where does the legal risk lie? Well, the legal risk lies in the amount of time that something's been going on, and the longer that you have a problem and it hasn't been solved, the more likely it is that someone's going to find out about it and care enough about it to do something. The more people that are involved, then again, the more people there are, the higher your base population in order for someone to be cross enough about something to do something about it. If there is something plainly obvious about what you should or shouldn't have done, then that tends against you, and also how badly behaved you've been. So the phone hacking cases are a great case in point. You know, egregious activity, someone finds out about it, and then Trinity Mirror or Reach PLC, as they now are paying out a large amount of money because of the egregiousness of the activity that was being done in their organisation. Even if you get sued, I don't mean you're going to lose. And I've tried to kind of break down here a sort of set of options around how claims might pan out. And the one that is most helpful for me, because I normally act for, as I say, organisations, is that the organisation hasn't actually done anything legally wrong. You've got someone who's motivated, but the organisation's able to justify that which is done, or more properly, the claimant can't justify or can't prove that the organisation has failed to act as it should have done. And if you're acting for the defendant in that set of circumstances, then happy days. The ones that are a higher risk for an organisation are circumstances where an organisation can't evidence that which it has done or that which it should have done. And even if there's no legal obligation to keep a record, then if your evidence doesn't stack up, then you're going to be in difficulty at some point down the line. An organisation has failed to put appropriate measures in place, and we'll talk about that in the data protection sphere in a little bit, or decision makers have just gone with what they want to happen, ploughed ahead with it, and haven't thought about the consequences or legal implications of doing what they're doing. And that creates both a kind of reputational dimension and also a legal problem as well. And then the final kind of category of case is ones where the organisation hasn't actually done anything wrong, but it's responsible for someone who has caused harm or has who's created the problem, and that's what's known as vicarious liability. And we'll talk about that in the data protection sphere, and the most recent kind of big case in that sphere of Morrison's in a little bit. How do claims work? Well, there's a kind of process that is gone through, and first of all, there's got to be something that's given rise to the claim, and there's a kind of generally, if you're in the NHS sphere, you might get a complaint, you might get something that's you might be doing a serious investigation report or what have you. The facts have arisen, and there's things that are happening in the background. Then it's incumbent on the claimant, so the person who is feeling wronged, to write what's called a letter before action or a letter of claim. And that's that second step on the graph there of pre-action correspondence. The organisation's got an opportunity to respond, and a lot of things kind of go away at that point. But then it may be that the claimant pulls the trigger on commencing litigation, and they issue a claim form and serve proceedings on the defendant. The defendant then files their defence, and then there is a whole series of steps that are then gone through, like exchanges of evidence and maybe instructing experts, disclosure of witness statements, and eventually you might get something that goes to trial. And only a very small proportion of cases actually ever end up at trial. So just by way of some recent statistics, in the last quarter of 2019, which is the most recent set of figures I could find, there were about just shy of 500,000 claims that were issued, but only 17,000 cases went to trial. So, you know, one in I can't even do the maths. One in 20 cases ends up in trial in that scenario, and that creates a kind of or throughout the kind of litigation process, a lot of cases will settle.
Just a thing there for you. One of the things, as you can see there, as Andrew said about limitation, typically 6 years to bring a claim. What that means in records management side of things is that for the most part, Limitations Act 1980, but that's actually related to adult claims. If the child the person under the age of 18, who I guess is a child, has an accident or an incident, then they have until their 18th birthday plus 6 years to make a claim.
That's right, yeah, and depending on the nature of the claim, there's different limitation periods. So personal injury is 3 years, equalities claims are a year, judicial reviews 3 months. If you're dealing with something which relates to a deed, 12 years. So there are different time periods that apply to different kinds of claim. And just going back to your example as well, very sadly, some of the cases that as a firm we deal with involve catastrophic injuries at birth, and someone may never gain mental capacity to bring a claim on their own account. And there, where someone doesn't have capacity, then there's no specific limitation period. That period could be quite open-ended, and certainly in the health sphere, that is sadly pretty common to come across.
Also, Patients Act 1980 has that ability that if you again, so before the recording was started, we were talking quite candidly about stuff, was that I totally forgot my thread. The claim side of things, I'm sorry, I'm trying to think of the exact wording. So what we were talking before the call was about the wording of how law is written. And in Limitations Act 1980, it says from the point at which they know.
Yeah.
So determining at what point they knew about the thing that happened is open-ended for retention side of things. And so you have to take a risk-based approach on these side of things.
Absolutely. And some of it might be really obvious, you've chopped the wrong leg off. But others, asbestosis claims, really hard to predict, really and the point at which an injury becomes apparent is going to be a pretty long time after the date of the incident that gives rise to the harm. Further time delay then occurs during the litigation process itself. So on average, a fairly big case could take at least a year to get from the starting pistol being fired through to the first trial. And then if you end up in the appeals territory, then you might be spending years dealing with things down the line. This is a kind of just quick map of the courts that are in the UK. Most civil claims start in either the county court or the high court. Obviously, if you deal more on the FOI side of things, then you might be more familiar with the tribunals, or if you deal with mental health or things like that, where there are specialist tribunals that are in those kinds of spaces. From there, you might end up in the Court of Appeal if you're lucky or unlucky, depending on how you view it. And then from there, the Supreme Court is the kind of top level of English and Welsh courts and Scottish courts. And that is where Baroness Hale and various others sit. It used to be the House of Lords. If you're in data protection territory, given that that's European legislation, things could ping off to the European Court of Justice, and that can carry on going at least until December. We'll see what happens after that. A few kind of points on the records management side of things. What does a good record look like? Well, not that one, and definitely not this one. And we see cases coming up time and time again where even if there may not be a statutory obligation to keep a record, the quality of the record keeping or the quality of the records of the decisions that have been made is what causes organisations to have a problem. And this is a line from the Employment Tribunal judgment in Samira Ahmed and the BBC. Samira Ahmed presented a programme which was very similar to Jeremy Vine's Points of View programme. For Samira Ahmed's programme, she was paid 400 quid. Jeremy Vine was being paid £3,000 a time for Points of View. 15 minutes, someone else wrote the script. If anyone needs a new presenter for Points of View, then hopefully you'll be impressed by my presentation skills today. I don't know if anyone's heard from the BBC, but I'm available for this kind of gig as well. And you get into the kind of judgment of the Ahmed case, and this is a sort of line from it where the tribunal is talking about why the BBC was paying Jeremy Vine £3,000 a time and why it was paying Samira Ahmed £400 a time. And the problems that arise are, well, it all took place a long time ago and half the people don't work for the organisation anymore. But, if if at the starting point you had some sensible pay structures that were written down somewhere, or some processes that were written down somewhere, and some records of the decisions that you've made, then actually you might be able to justify why you're paying Jeremy Vine 5 times as much for basically doing the same job as Samira Ahmed. And the BBC comes a cropper because it doesn't have that transparent or consistent process, and doesn't have any records around how pay levels have been determined. So not only were there no records in relation to the specific decisions, but there was no records about, you know, the process as a whole, and that causes difficulty for the BBC. And if I were them, I would have got rid of that far sooner than they did. Why is this important in the world of data protection, which, as I say, is kind of the focus of the case law element of this? Well, there's a whole series of statutory or obligations within the GDPR itself that talk about keeping records. So, you know, either in general principles terms, like the accountability principle in GDPR, or more specifically, requirements to have policies in place under Article 24. But then the whole structuring of the legislation talks about maintaining records and being able to provide an explanation either in specific cases or in general terms in the legislation itself. And we'll touch on some cases that have explored some of those issues across the board. We talked earlier on as well about this idea that while some legislation you might be thinking in kind of a black letter sense of what the law says, information law is often grounded in a kind of world of proportionality. So why are you doing what you're doing? Why are you not doing what you're not doing? Can you justify the approach that you're taking? Why aren't you taking a different approach? And the ability to enunciate that, or to be able to point to some records about why you're doing what you're doing or why you're not doing what you're not doing, is super important. And as I say, a load of the stuff that's going on at the moment around the kind of contact tracing app points to these issues. You know, there may be very good reasons for why you have a centralized model rather than a decentralized model of contact tracing. And
a huge issue in England and Wales around our Public Records Act being so far behind the times, it's unreal. So we have obviously Public Records Act 1958, and we have Local Government Records Act 1962 and Local Government Act 1972. I always switch the 2 years between the two, so might not be quite right on this, but it might be. And basically is that the Public Records Act 1958 only applies to civil service and NHS. And for the most part, it basically says you only have to send stuff to archive after 20 years. And the other two acts, one makes way for an archive to be created or library to be created, and the other basically says you must make appropriate measures for records or something really vague and unhelpful in that, and that's literally all we have. And to the point where local gov organisations don't necessarily have anything that says they need to archive, except make appropriate arrangements. That's what it was. And for the most part, they basically follow the same rule as the Public Records Act, but for 20 years. But there's not actually anything that actually requires you to do it. So yeah, I'm thinking about turning into an activist and doing lobbying or something for records management, because, you know, I'm sick of this.
I absolutely sympathise, and so one of the other bits of legislation that I advise on a fair amount is the 1960 Public Meetings Act, and at what point you have to let people into public meetings. It was the first piece of legislation that Margaret Thatcher wrote, and when she was a backbench MP in the very early 1960s, and it's hideous. It's really badly written. It's completely not in keeping with the times, and the application of these kind of like 1960s principles or 1950s principle to the world that we're in now, I think, is actually really there's a real art and skill to that, and it's definitely not easy. So yeah, it is a fraught area, and I have a lot of sympathy for anyone that's in this space. In terms of what you get on, and this is on the data protection side of things, if you bring a claim, well, the threshold for what you have to show, if you can show that someone has failed to comply with their obligations under information law, for getting damages, is pretty low. All you need to show is that someone is distressed, and the cynical person might say, well, showing distress isn't that hard to do, and that comes across. And if someone has just suffered some distress, then they might get some compensation somewhere in the region of 3 figures or 4 figures, or possibly low 5 figures. And there's 2 kind of key cases on that. TLT and Home Office and Brown and the Metropolitan Police will talk about some of the cases where people might have ended up with more money in a little bit. Spoiler alert.
You can't see right now, Andrew, but I'm very distressed. I have my hand on my forehead in a very dramatic manner.
You make my point extremely well there, Emily. And yeah, if you're interested in this space, have a look at the TLT judgment, because basically the judge is like, some of these people don't know what a computer is, and they say that they're very upset by the fact that this database has been put online, but they don't really have a clue what's going on, and they've just been told to sign a witness statement. And I'm not convinced by their evidence, but I'm going to give them £2,500 anyway. So yeah, if you're acting for public sector or data controller organisations, then this is a kind of challenge that you face. There are, though, a whole series of cases where someone has suffered something which is way more than just feeling a bit upset or a bit pissed off, and the compensation kind of moves commensurately with that. People might want things that aren't just money. So Guys and Shah, which is an absolutely bonkers case about 2 people setting up websites in each other's names and slagging each other off. There, what they wanted was an injunction, so a requirement and a court order that says that they have to do things or not do things. And if you're involved in judicial review claims, which is claims involving public bodies, and the reasonableness of public bodies' decision making, which goes back to the records management points, then there are various other remedies that are associated with that kind of space. What we see a lot of is claims that cut across a whole range of different areas of law, and that goes back to people's motivations and the circumstances that have given rise to a claim. So you might get something which is a data protection claim, but it's also baked into an employment claim, or it's baked into a confidentiality issue, or it's got elements of a tort of misuse of private information or human rights angles or negligence or whatever else. There's a whole sphere of cases that interact with one another, and people often plead lots of cases together in order to try and get the result that they want. Also worth bearing in mind that if you win and you go to court, and you win, then your legal costs should be recoverable from the loser in litigation as well. And although you might only get £2,500, the cost bill is likely to be 10 times that, at least, probably 100 times that, given the way that some of these claims are going. Where are the problems at the moment? Well, the legislation, and this touches on Emily's point earlier on, some of the legislation I think is terribly drafted. Some of the obligations are pretty prescriptive, but some of it is very agnostic or very vaguely drafted. A requirement to have reasonable security measures in place. What does that look like for organisation A? Well, something potentially very different to organisation B. Some of the obligations that attach in data protection are pretty onerous, so dealing with things in specified timeframes. Some of the hurdles that you have to jump through if you're dealing with subject access requests can be pretty heavy duty. The measure of what harm someone has to show is pretty low, and we've talked about that in the distress sphere. For people working for large organisations, do you know what your other bits of the organisation are doing? Anyone in a compliance role, probably not, because organisations often have great ideas that they don't really tell anyone about until the 11th hour. And even if you have great policies and procedures, is what's happening on the ground completely different to what's being described in your policy and procedure, and how do you reconcile the two things? New tech is a great way of giving rise to claims. One of the theories that happened when GDPR came in was obviously that everyone was going to get hit by mega fines. That hasn't happened, and the agenda for boards and the appetite for risk has probably gone up quite a lot since then, and people are starting to cut corners a little bit. But I don't think the risk is really from regulatory action in the sense of fines. I think that the risk more obviously comes from group litigation, and the way in which people can bring claims now, even if it's a low value claim. If one person sues for £2,500 for a big organisation, that might be a drop in the ocean. But if 100,000 people sue for £2,500, then all of a sudden you're looking at a heck of a lot of money, particularly when there's an enormous cost bill that's attached to the same litigation. Definitely individuals have more knowledge of their rights. They may not have the right knowledge of their rights, but we see all kinds of bits of data protection or prayed in aid in other issues, and that causes some challenge. And as I say, the information law angle to a claim is often a vehicle on which a bigger grievance is being aired. So someone might be an aggrieved employee, and they then stick in a subject access request. The subject access request isn't going to solve their problems. It might give them an email where someone calls them a rude name, but actually their motivation isn't really about their information rights. It's about something else. Lots of opportunities for redress, and that creates a risk. If the ICO says you've done something wrong, then it's pretty hard to defend a claim where you assert that you've got it all right. Organisations probably are underfunding their compliance teams and not putting enough money into data protection. There's a quote on health and safety, which is that if you think health and safety is expensive, think about how expensive having an accident is. And I think that's also true of information rights. And also information rights obviously cuts across the board, both in terms of your relationship with your customers or your service users and your employees. It goes everywhere. And if you're working in the brave new world of lots of organisations working together, then you might end up in a situation where you're footing the bill for one of your partner organisations' problems, and there are provisions in data protection law that could create some difficulties. It's not been particularly litigated at the moment, but it presents a risk. So the things that we're going to talk about in the kind of case law update for the next 45 minutes or so is vicarious liability and the big case of Morrison's that's been in the courts, or the judgment came out in the last couple of months. Secret recordings and whether or not someone recording an interaction with a doctor or indeed you, if you are in a customer facing role more generally, is permitted. The circumstances in which you can disclose information to other parties and what use you can make of that, and where that may leave things. There's a few cases that I just want to touch on in that space, and also doubling back to where we started from, documentation and decision making, and the M and Sussex Police case, and also Bridges and South Wales Police as well. We can talk about subject access requests, we can talk about FOI, and if you've got anything else that you want to talk about, then very happy to talk about that instead. Morrison's have a bad run of luck in being involved in vicarious liability cases. They were involved in a case about 5 years ago now, involving two gentlemen, Mr. Khan and Mr. Mohammed. And Mr. Khan was an employee of Morrison's who worked in a petrol station, and Mr. Mohammed was a customer of the petrol station. He came in one day and asked to use the kind of photo printing machine that was in the petrol station little shop thing, and Mr. Khan took some animosity to Mr. Mohammed and called him a string of racist names, chased him out of the shop, and then beat him up in the car park. And Mr. Mohammed that wasn't part of Mr. Khan's job description, I should say, at this point. Mr. Mohammed then sued Morrison's and said, look, this was someone who beat me up in your car park. He was an employee of yours when he did it. I know it's not part of his job description, but you, Morrison, should be responsible for the things that Mr. Khan did. And that trundles through the court system, and there's some to and froing around whether or not Morrison should be responsible for that. And the upshot of that case was that Morrison should be responsible, and that follows a run of cases where the courts have taken a fairly expansive approach to people who do naughty things whilst they are employees, and the worst of those cases are a string of child sexual abuse cases where priests or teachers are abusing children in the course of their work, and the courts say that the employing authority, be it the church or the education board or whatever, should be responsible for the misconduct of the individuals. There's some various other cases involving swimming teachers and responsibility for providing safe environments during swimming lessons where things are outsourced, and there's other cases involving foster parents and the extent to which foster parents should be responsible, or the local authority should be responsible for the things that foster parents do. But the upshot of all of those cases is that the courts have generally taken an expansive approach to vicarious liability. Now, how does that apply in the information law sense? Morrison's reappear in the fray in a data protection case, and that concerns Mr. Skelton. Mr. Skelton is a payroll auditor of Morrison's. He has a sideline in producing or selling through an eBay shop some muscle supplements, and he's paying for the postage.
Probably with legal highs.
And legal highs.
Oh.
Or, yeah, kind of mystery substances. Then what he's doing isn't illegal. I should emphasize, though. Yeah, they are legal highs. They're whey protein based powders and various other things, and he's sending that out through the Morrison's post stream. He's not disguising that as being post that's being sent out as Morrison's. They don't have club cards at Morrison's, do they? What's the Morrison's equivalent? He's not pretending that it's Morrison's post, but one day one of these bags of mystery powder splits open in the post room at Morrison's, coating everything in a white dust, and the police get called, and they turn up in their hazardous material suits because it could be anthrax, it could be cocaine, it could be something equally exotic, but no, of course it isn't. It's just the things that Mr. Skelton's selling on the side. Mr. Skelton gets given a verbal warning that gets written down for people in the information and records management sphere. I leave that to you at what point a verbal warning starts becoming a written warning. But anyway, he bears a grudge against Morrison's as a result of that, and his job involves him making a copy of payroll information and sending that to Morrison's auditors. And at the same time as he does that, he makes a private copy, and in the course of his grudge building up, he then decides to put that on the dark web and sends a copy to various papers. He tries to frame a colleague for the loss, and the court, in the first instance, the High Court case, says Morrison's security measures were fine. They weren't causative of the issue that was in play here. So Morrison's aren't responsible for Mr. Skelton's actions, but applying the kind of cases that have gone before, and in particular the other Morrison's case, they say, well, Morrison's and Mr. Skelton's your employee. It's right that you, Morrison's, should be accountable for that which flows from Mr. Skelton's actions. Now, if you're Morrison's and you've got Mr. Khan walloping someone in the car park, one claimant, one punch, one claim, you get to Morrison's and Skelton, then you end up with 5,000 claimants in the first instance. And Morrison's has already spent like £2 million trying to tidy up the mess that Mr. Skelton's made. the court says, well, tough. You're still responsible, and you're vicariously liable for Mr. Skelton's actions. And as I say, this flows from this kind of expansive approach to vicarious liability that's gone before. And Morrison's, though, aren't happy about this judgment, understandably, and they and their insurers keep appealing it, and it goes against them in the Court of Appeal. But in the Supreme Court, they win. And the court says, well, actually, none of these earlier cases are particularly relevant to the situation that applies here. And the real thing that you need to look at is whether Mr. Skelton's conduct was so closely connected to the acts that he was allowed to do for the purposes of his job, that it's fair and proper to make you, Morrison's, responsible for his actions. And the court says, well, actually, no, he was only given an opportunity to make this copy of the records in the course of his work. It wasn't part of his job to do that. It just gave him that kind of spark in order to light the fire. And the fact that he was trying to do this in order to shaft Morrison's was an important factor in terms of saying that Morrison shouldn't be responsible. I take issue with that because I think all of those cases where it's child abuse, it's situations where people are behaving not to further their employer's business, are cases in the past where the courts have said that the employer should be responsible, but here the court kind of comes to an opposite conclusion. And the court kind of fudges things and says, well, in light of all the factors, and you take account of the passage of time and various other factors that are in play, Skelton's motivations and everything else, then it's not fair on Morrison's to impose vicarious liability on them for this breach. So good news. Are data controllers home and dry? No, because
in terms of that, sorry, I'm just on that point. For me, is that like some of the things. So I actually watched the video of the Supreme Court deciding. And I have to say, I did breathe a massive relief, purely on the basis of that. It basically, to me, would have screwed over information governance in an organisation royally, because it didn't matter what you did, whether you trained your members of staff, you did as much as you could. Someone could still do something and you'd still be responsible. So what's the point in a budget for an information governance that's not going to be effective in the court of law? Yeah. And some of the things that he did in order to cover his tracks and like try to fit up this other person with like burner phones and using his colleague's computer and setting up an email in his colleague's name, and he put it on the dark web, and when it didn't catch any traction, he then put it all on disc and sent it to newspapers, and the newspapers then tipped Morrison's off rather than publishing it. It was all cleverly calculated, but I think his colleague also had a disciplinary situation, which is he basically played on that. So I'm just sort of like, I'm quite thankful actually that it's gone to not vicarious liability, because I think it would actually put a real dampener on what I do as a job. So I've got a bit of a self kind of like interest in it, but just in general for the information governance sphere, what this actually has meant, I think, is really important.
Yeah, I think that I subscribe to that, and you can't guarantee that you've not got any bad apples in your organisation, and should you be responsible for that? And I think there are circumstances where, and the court says, this isn't a completely closed door. So do bear that in mind on the kind of vicarious liability side of things. But also, let's say that that Skelton had misaddressed the envelope, and rather than when he put it onto USB stick, and rather than being motivated to screw Morrison's over, he was just really shit at his job. Now, the same harm arises to the individuals in that set of circumstances. The end point is that someone still suffers some harm, but you get different answers now on, well, should the employer be responsible for that if the employee is negligent in performing his tasks, then yes, you should. If the employee is off on a frolic of their own, then you aren't. The harm element is the same. So I think there are some tensions in where this leaves us. And actually, that's one of the things that the court's kind of critical of, is that the judge is effectively saying the court started with what the right answer should be for the individuals, and unfortunately, life is unfair. There are some things that are covered, there are some things that aren't covered, and you can't have a sort of total answer across the board. And so I sympathise. I think where this leaves us is it's still incumbent on organisations to have a good information governance programme, and the size of the organisation and what it's doing will have a bearing on what that programme looks like. It's still important to vet and train employees, and the more hurdles that you can put in place to stop someone doing something that they shouldn't, the better, really. And the more that you can show that you've thought about the various risks and tried to manage them, the better as well. Slightly different sphere. What happens if it's a customer that's up to no good? If you want to put something on in the background because you're bored of my voice, then you can watch the Gene Hackman film The Conversation, which I think is on iPlayer at the moment, and it's all about making secret recordings and stuff. And the reason that I talk about secret recording, because Mustard and Flower case from the back end of last year concerned a secret recording that had been made by a lady, Mrs. Mustard, of an appointment with some doctors, and she made
Cluedo.
Sorry.
This sounds like a game of Cluedo.
It does. Mrs. Mustard in the GP surgery with the tape recorder or iPhone, and she had motivations, and her motives were, she said that this was all to do with making an aide memoir of the hearings, and so that she could evidence and remember what was going on. And what she also did was put in copy all of these recordings and write them out, and then put them into the litigation. And the lawyers for Mr. Flower, who was the driver in a road traffic accident that had given rise to all of this in the first place, said, well, hang on a second, we don't want to bear the cost of all of these extra reports or recording or evidence being used. It's just cost building that's being done by the claimant, and therefore we don't think that the recordings should form part of the litigation, and they were unlawfully made, and therefore they shouldn't be admissible in the court proceedings. And the court looks at this as an issue, and they say, well, hang on a second, she's making this recording for personal purposes, and GDPR bites on organisations doing things for non-personal purposes, or individuals doing things for non-personal purposes. And because of the circumstances here, it's outside the scope of GDPR, and therefore she can introduce it into evidence. And this actually contradicts or in my view contradicts a European case called Boyvids, which is in a sort of similar-ish space, where someone recorded their arrest and interview at a police station and then put it all on YouTube. But I think kind of where this case leaves us is, bear in mind that anything that you or your colleagues do could be recorded. In other words, it's impossible to stop a recording being made, either because of a kind of power imbalance, or just that you don't know that the recording's being made in the first place. Obviously, we're all being recorded tonight, and I regret using the S word earlier on. The follow-ons from this as a case, therefore, are, well, if these kind of recordings are admissible, then if you're acting for an organisation, or you're involved in information governance processes in an organisation, what to do about it. Well, it'd probably be worth having some kind of policies about where recordings are a good idea or bad idea, and bad ideas are kind of, example there, public areas of hospitals, or where things are really about third parties, or where someone is making a recording not with the intention of using it but just to wind you up, and that's something that we come across from time to time. It's worth making sure that staff are aware of the fact that people can make recordings and that recordings might be helpful. A really good example of that is the Metropolitan Police and body-worn video, and they are evangelists now for recordings and making people and actively allowing people to make recordings if that's what they want to do, and facilitating recordings and communication skills and speaking slowly and clearly and moving your lips enough so that people can understand what's being said, is all helpful in that space as well. So rather than trying to stop recordings, turn the negative into the positive and make it so that you're focusing on making the best possible recording. That's your shield.
There's something to say there just about recordings versus sort of like listening in. One of the functions of Apple earpods thingy, earphones, whatever they're called. They have a functionality that if you leave your phone in a particular room and switch on listening mode, is that if they've got their earphones with them, they can leave their phone in their pocket upturned so that you can got the speaker part and then walk out and still hear what's being said. So when you ask them to leave a room whilst they discuss your case, is that they're actually still able to listen in anyway.
Yeah.
So just a thought there really is that sort of like about, whether or not you're asking someone to leave or if they're just recording it in front of you.
Are they actually leaving, and being aware of, as you say, the kind of technology on that side of things is worthwhile. A lot of what I deal with is subject access requests, and the perception or the recurrent problem that people assume that instant messenger doesn't continue to exist, and that things that seem ephemeral or things that seem kind of limited in time and space actually carry on forever. And so being aware of that and training people up on what to watch out for remains super important. Disclosures and the use of disclosed information are the kind of next couple of cases, and Cooper and National Crime Agency. Mr. Cooper was a employee of the Serious Organised Crime Agency, which became the National Crime Agency during the lifespan of the case. He had a skimful on a night out and got into some trouble with the police, and then told the National Crime Agency that he'd been arrested because of the nature of the work that he did. It was important for him to be upfront about that. The National Crime Agency got a load of information from Sussex Police about the arrest and Mr. Cooper's behaviour during the course of that and leading up to it, and the National Crime Agency then used that as part of a misconduct investigation about him. And in light of that, Mr. Cooper was sacked, and he then appealed against that dismissal and said that the way in which his data had been obtained and used from the National Crime Agency was unlawful. And this is a really good case if you ever want to think about how the courts might look at being able to justify your actions in terms of the legal basis for doing things. And the court runs through in quite a lot of detail all of the potential legal bases that could be used by the National Crime Agency to justify the use of the information about Mr. Cooper. And in particular, it says that it would be entirely justifiable based on consent, contract, legal obligation, public interest, legitimate interest, and equivalent conditions for special category data as well, given that this or sensitive personal data as was the more sensitive information. Worth bearing in mind this is a Data Protection Act case, and probably the court now wouldn't say that this was a consensual use of information by the National Crime Agency, and given that the National Crime Agency is a public body, it probably wouldn't be able to rely on its legitimate interests either. But there are still a series of other grounds that it could rely on as well. And then there was a kind of bit of an afterthought issue around, well, should the National Crime Agency have said more to Mr. Cooper about what was going on with his information? And the court said, well, there's not much to that and it's not been properly argued, so we're not going to look at it in detail. But I think this is a really useful case about how you can justify your use of information and the importance of, from a starting point, thinking about how you can make lawful that which you want to do. I mentioned earlier on the fact that we get these cases that have a number of different strands to them, and Scott and the LGBT Foundation is a good example of that, where claims come across a whole different series of legal domains. And this concerned Mr. Scott, who'd asked for some therapeutic support from the LGBT Foundation, and during the course of the consultation, he told the foundation about some mental health issues and some substance misuse, and there was a risk assessment that the LGBT Foundation did about him, and said that he's at moderate risk of self-harm. And as a result of that risk assessment, the LGBT Foundation said, well, we're going to have to talk to your GP about this to help get you some ongoing support, and that we could do this in any event because we're really worried about you. And at that moment in time, Mrs. Scott didn't complain about what was going on. And from a records management perspective, helpful case, the signs, the forms that Mr. Scott had filled in specifically said we might the LGBT Foundation might share information in that set of circumstances. The LGBT Foundation also then provided that information over the phone, and Mr. Scott brought a claim under two different angles. He said this was a breach of data protection law and also his confidentiality. And the court says, well, actually there isn't a data protection claim here because the disclosure that's been made is a verbal disclosure, and data protection law is concerned with recorded information. If something's just in someone's head and then enunciated over the phone, then there's no recorded information there. It's just stuff that's come out of someone's mouth, and therefore the data protection claim failed as a result of that. And he was potentially better bringing his claim based on the law of confidentiality. But even then, the court said, well, the LGBT Foundation had not only been able to justify the disclosure on the kind of immediate harm test, but also because they'd specifically said to Mr. Scott prior to him providing the information, we might need to disclose some information about you to your GP if we're sufficiently concerned about your welfare in order to do it. So there was a kind of qualification to the duty of confidentiality that Mr. Scott was owed, and because of that gateway, the claim went nowhere. And in any event, the claim, the disclosure could be justified on the basis of the concerns of immediate risk to Mr. Scott that the LGBT Foundation had. So helpful for the LGBT Foundation in that set of circumstances. And a slightly glib point that, you know, if you've not written anything down, then that helps provide you with a defence on the immediate processing of personal data angle. But obviously the important thing for LGBT Foundation there was the fact that they had decent records which could explain what they'd said to Mr. Scott about what they were going to do with his information. Another health case, and actually this is a Cat 6 case, which one of my colleagues is dealing with in the clinical negligence sphere. And this is another, it's a really sad case, and it concerns a family where the dad of the family had Huntington's disease, which is a progressive neurodegenerative disorder, kind of dementia. that causes personality changes. And prior to X being diagnosed with Huntington's, he shot and killed his wife, and he then was put on trial for that. And the upshot of that was the diagnosis of his Huntington's disease, and that hadn't formed part of the kind of evidence to the world at the trial. That had all sort of happened after the event. And he had a series of discussions with his clinicians about the fact that he's got Huntington's, and whether or not he wanted his family members to know about the fact of his diagnosis. And specifically, he didn't. He didn't want his daughter, who in the judgment is anonymized as ABC, to know about the fact of his disease. And ABC became pregnant, and she told her dad about that. And ex-dad refused to again tell ABC that he had Huntington's. And Huntington's is a genetic disorder, and the risk to ABC is that she has a 50% risk of getting Huntington's, and that the baby in turn has a risk of getting Huntington's as well. And X knew that the fact that there was a risk of a progressive neurodegenerative disorder would impact on whether or not ABC would want to continue the pregnancy. And in the end, the hospitals involved didn't tell ABC about the risk of Huntington's, and they respected X's wishes, and ABC had a baby. Sometime after the baby was born, ABC said ABC was accidentally told by the doctors that her dad had Huntington's, and consequently there was a risk that she might get Huntington's, and consequently there was a risk that her child might get Huntington's as well. And in fact, ABC then had a genetic test which confirmed that she would in due course get Huntington's. And ABC brought a claim and said, you, the hospitals, should have told me that I was at risk, because that would have informed my decision about whether or not I would have carried on with having a baby, and I would have got a termination in that set of circumstances. And the court looks at whether or not there is this duty to warn ABC in the face of X, who is owed a duty of confidentiality about the risk of Huntington's. And the court says clinicians have an obligation to think about these issues and to do a balancing exercise between ABC's right, in this case, to know about the risk, and X's right to medical confidentiality and the public interest in the NHS broadly providing a confidential health service. And as long as they have thought about those issues and come to a logical and reasonable conclusion in that set of circumstances, there's no specific duty that they need to tell ABC or someone who's at risk of a genetic illness about what's going on. And there may be circumstances where there is a duty, but it's not a kind of general across the board set of circumstances. But I think this is an interesting, and it's a devastating case. It's super. The facts are awful. Andrew,
one of the things that I'm thinking of in this is that I have no medical background other than my records management. And that's not even medical info. So but I just think to myself is that there are so many degenerative diseases and things that can be passed on through however that sort of like if you try to rule out every single one that might have an impact, surely that she doesn't need to know because she could have got something else anyways.
Yeah, I think this is a really interesting point, and as the cost of genetic testing goes down, the ease of doing genetic testing goes down, the ability to be able to pinpoint specific genes or chromosomal issues or what have you that give rise to particular kinds of illness becomes more common, then yeah, I wonder if we will start to see a kind of recasting of how far the duty to know goes. And we acted for the trust, or from our perspective, we take the view that there isn't that specific duty to warn, and that the duty wouldn't apply in the set of the set of circumstances. You could flip it on its head and say, well, what happens if you know that someone's going to go out with a knife, or someone's got a gun, or whatever? Is there a specific, or someone's got a psychopathic disorder that means that they're going to, that they're going to cause specific harm to someone? There's American cases, Tagalov, which says that there is that duty to warn in that set of circumstances. But moving it across to the UK, I think this is a really interesting area of the law being, well, there's no specific duty to tell someone you have to do a balancing test, but is there an ethical imperative? And if so, which way does it go?
It's something you kind of feel like you need like a crystal ball in these kind of things, because when I think about so I think it's quite widely known in the public that my mum died when she was 53. And sort of like you said, if I knew that I was going to die at X age, then I wouldn't have had children, or anything like that. It's kind of like you need a crystal ball for majority of these things, and perhaps, I don't know. But
is it better not to know?
Yeah.
And I think this is utterly fascinating as a conundrum, and I don't know what the answer is. I don't think there is an answer, or I think there are lots of answers, and everyone could come up with an entirely reasonable view based on their own personal circumstances and perspective. And actually, that, I suppose, is one point that's worth bearing in mind with this. Often the courts, also particularly true of data protection issues, they're not, the law isn't absolute. The fact that person X would do something different to person Y, or organisation X has done something different to organisation Y, doesn't mean that what organisation Y has done is wrong, as long as their approach is reasonable. And if their approach is reasonable, it's justifiable, they've got reasons for it, they've got some records which show why they've done what they've done, or why they've not done what they've not done, as long as they can kind of stack that up, then that's fine from the court's perspective. So I think this is as I say, it's a kind of novel issue, but also one that reflects a lot of these kind of bigger ethical conundrums. A slightly less
just
ethical.
Just to let you know, Andrew, we have about a 5-minute warning here.
Smashing, fine. I will do read and price, because it's I'll leave you on the salacious and interesting case. Katie Price is a I don't know, how would you describe Katie Price? A television personality and former glamour model. Alex Reid is a television personality and former cage fighter. And for a short time, Katie Price and Alex Reid were married. And while they were married, Katie Price obtained some footage of Alex Reid in his alter ego Roxanne, and some footage of him engaging in some sexual conduct. And Katie Price promised to delete that footage, but in fact then started posting it all over the internet and sharing it via MMS with people, and shared it with at least 50 other people. And Mr. Reid brought a claim against Katie Price for breach of confidence, misuse of private information, breach of contract, harassment, and compensation. And he wanted compensation and injunction and various other things as well. And he also wanted £60,000 worth of damages as a result of Katie Price sharing that information with others. And this is a case where the courts start to think about, well, is that the right amount of money for someone that has been distressed? And the court says £60,000 is that there is a list of how much money you get for various kinds of personal injury. And £60,000 is the equivalent to being blinded. And Mr. Reed's distress was very real, but to say that his life had been destroyed by Jordan's actions wasn't quite on point. And
you're going to have to step up my distress game.
Yeah. And so the court does say, though, he has had some significant distress. He was really worried about this, and Katie Price was unrelenting in her behaviour and a complete horrible person to Alex, and therefore the degree of distress that he had suffered was very, very high, and therefore the money that he was entitled to across all of these various kinds of claim, £25,000, so less than 60, but more than £2,500. And if you want some comparators, then that is the equivalent to moderate psychiatric harm or a moderately severe neck injury. Now, £25,000, Jordan is bankrupt, and so he's never going to get that money, and he's also not going to get that £150,000 in costs that his solicitors have managed to rack up in relation to this case. So this is a useful case on where quantum is now. And the very, very last thing that I just wanted to talk about, and Sussex Police, and actually this one is relevant for records management. The police force ran a record business crime reduction partnership, which involved them sharing information about people that might be shoplifters or various other kinds of criminal behaviour that might happen in Brighton. And the police shared some details of a 16-year-old called M, and that included information which was most obviously relevant to kind of stopping her from shoplifting, but also a load of stuff which wasn't really relevant. Bail conditions, an assessment of her vulnerability to exploitation was also shared with the Business Crime Reduction Partnership. And M said, look, this isn't lawful sharing of my information. And she challenged both the kind of general scheme of the information sharing and also the specifics of some of those disclosures. And the court looked at the information sharing agreement that the Sussex Police and the Business Crime Reduction Partnership had in place and took this kind of holistic view of it and said, well, the documentation isn't great here, but it's enough. You take it all in the round, there's something to do with training and vetting. They have thought about what should or shouldn't be shared. They've put some security measures in place, and therefore the overall scheme, in the great scheme of things, is lawful. But what the police couldn't do was explain why the information that they shared with the Business Crime Reduction Partnership also included information about M's vulnerability to child sexual exploitation. There was just no relevance to that in terms of whether or not she'd be shoplifting. And the court is also very critical of the record-keeping practices of the police and the fact that a load of the disclosure was really, really late in the day. And also the drafting of the information sharing agreement as a whole. You know, the law now is about transparency, and here the documentation was pretty half-baked, and a really useful case in point of thinking about data protection not just as kind of like holistic thing, but also as justifications for individual decisions, and also the fact that if you're dealing with a whizzy project or something that involves sharing lots of information, that actually you need to keep things under review as well. It's not enough just to have this kind of one point in time exercise and thinking about what your review arrangements are. Same themes are put in the South Wales Police facial recognition case, where they say things are lawful, at least there's been some kind of attempt at a data protection impact assessment, and that's enough for us. The police can show that they've thought about things because they've got some documentation. We're not going to try and interrogate that too carefully, as long as they can look at it in a sensible way. If you want to talk about subject access requests, I can do that, but you're more than happy to leave you with the slides if you prefer.
I'm staring at my pasta that's going cold.
I will love you and leave you presently. But in terms of where I think kind of case law is on information law and specific data protection law at the moment, well, we've not had that many GDPR cases. The dust is continuing to settle or evolve, depending on how you want to look at it. There probably will be some more guidance this year, depending on what happens with coronavirus, but and that also will have a knock-on effect on the number of judgments that are going through the system at the moment. Data protection claims don't exist in isolation. They're generally pleaded in connection with something else, and part of a broader package of tools that people have got to enforce their rights. And as I say, go back to the motivations of people bringing a claim. Often they're trying to achieve something else and using information law as a vehicle for that. And I think the courts are kind of taking this kind of holistic view of general obligations, and then if you have got a specific decision, then you need to be able to justify that specific decision as well. And from a records management perspective, as I say, think about what your documentation looks like, both for your general obligations and for your specific decisions as well. And that's about it. There's some FOI slides that you can look at your leisure. My contact details are here. You're more than welcome to use the slides. I'm sorry for swearing earlier on. And if anyone's got any questions, then I'm very happy to have a crack at them.
Thank you very much. I'm stunned because basically I feel like I've I hope you could take this as a compliment, but I feel like I've been to a university lecture, and that is something that I've been really looking for IRMS London, is that to really step up the game in the topics that we cover, because a lot of people that I'm in contact with, they are senior professionals, people who have been in the game a while, so general topics don't really go very far. You have to kind of have a business case to go to events, because you need some learning out of stuff. So you've kind of basically ticked all my boxes, and I hope those that, even if you're a beginner in this topic, have enjoyed this topic too. Does anybody have any questions for Andrew in the chat box, just while you have the opportunity, or any observations or comments? I just wanted to kind of, someone did write in the topic earlier in relation to Huntington's that people might not know about, is that apparently Huntington's often affects subsequent generations younger than the previous generation. As a result, ABC is likely to show signs of Huntington's at an earlier age than X, which, I didn't know.
I didn't know that.
Yeah, I didn't know from a medical, I just say state medical side of things. It's just my opinion, I guess, on the situation. So that's really interesting. Thank you very much for mentioning that. Your comments here, Andrew, that we're getting back is, thank you both, really good session. Many thanks, Andrew. Thank you both. Thank you. That was very informative. And lastly, that was super interesting again, supported by the fact that it went so quickly again. So thanks everyone for tuning in. I'm glad that you're still enjoying these. I think we're on like 6th week or something that I've been doing these. And I think this is the smoothest one that I've had so far in relation to tech issues. So, they are getting better slowly. As I said, next week we will be on the new IRMS webinar software, and we have Heather Jack, who is known as the records management big yin, someone I definitely look up to. Last but not least, starting in just under 10 minutes over on Twitter is IRMS Hour. Everyone can join in. And basically there's 5 questions throughout the hour, and everyone has a good chinwag about those questions. So if you look up the hashtag IRMS Hour, you'll find what's going on there. I believe Heather, our speaker for next week, is the guest person on the IRMS Hour this week. So look forward to talking to you on Twitter over there. See, this is what happens when I get hungry. So yes, I'm going to call it to a halt there, and just thank you everyone for coming tonight, and I'll see you again next week. Bye for now.
Thanks very much.